Welcome to the Napa Legal podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director, and I'm joined today for a special episode of our podcast with Kathleen Farnan, a current summer intern at Napa Legal, who's returning to us for the second time. We're delighted to have her with us and very excited to hear her thoughts on religious freedom, law, and policy. And we're also joined by a special guest, Professor Vincent Muñoz, who is a acclaimed author as well as a professor at the Notre Dame Center for Citizenship and Constitutional Government. In addition to Professor Muñoz's other accomplishments, my favorite is that he introduced my husband and me. So this will probably be my favorite episode of the Napa Legal podcast. And without further ado, I'll hand it over to Kathleen to get us started.
So Professor Muñoz, how did you first become interested in studying religious liberty?
Oh gosh, that brings me back. Well, let me just start by saying how pleased I am to be here with you both. Thanks for the invitation to be on the podcast. How did I first become interested in religious liberty? And this is going to date me. When I was in college as an undergraduate, there's a now famous case, the Smith decision came down, and it was very controversial at the time, remains controversial now. Justice Scalia wrote an opinion that said two gentlemen who had tested positive for drug use and who were fired for their jobs, they were tested for positive for drug use as when participating in a Native American church ritual. So they suffered civil and possible criminal repercussions for practicing a religious exercise. And the case gets all the way to the Supreme Court. And the question before the court is, can the state of Oregon or any state effectively make illegal this Native American church practice of ingesting peyote? And the Supreme Court, as everyone would probably know, said, yes, Oregon could make peyote illegal. And when I read that opinion, I wasn't sure if Scalia was right or not. On the one hand, it seemed like a quintessential violation of religious freedom. On the other hand, I could understand why the state of Oregon could make the ingestion of peyote illegal, and they didn't single out this religious group. So that case I found interesting because I didn't know where I stood on it. So I suppose that's what got me interested in it.
That's a great answer, Professor. And it segues nicely into our next question for you. As you know, at Napa Legal, we love religious freedom in all its forms, but we're particularly enthusiastic about religious freedom in the context of state laws. And as you may know, we put together the Faith and Freedom Index, which is trying to catalyze a renewed conversation around these issues. And I know in a number of your law review articles and publications, and particularly your recent book on religious freedom and the founding, you explore this theme. So can you talk a little bit about what the founders thought about religious freedom when they wrote the Constitution and Bill of Rights matters today, and what kind of additional context or understanding can we gain from looking at the origins of state religious freedom protections and their implications both for federal and state religious freedom today?
Well, your first question is in some ways relatively easy to answer. Most lawyers, at least, are interested in what the founders thought about religious freedom because the Supreme Court now has 5 or maybe 6 originalist justices. And so they say that the Constitution, the First Amendment, should be interpreted according to its original understanding. And in fact, in church-state law, as you know, even those who are not typically originalists have been originalists in church-state matters. So originalism has guided church-state matters. So if you're interested in the meaning of the Constitution or the court's adjudication of constitutional issues, that naturally leads you to what the founding fathers thought. Now, there are other reasons to study the founding fathers, primarily because they're especially thoughtful on these matters, and we have something to learn from them philosophically and constitutionally. So there are practical legal reasons, constitutional reasons, but also more philosophical reasons we might study the founding fathers. You asked a second question now. To remind me of your second question.
Yes, my second question was related to your book, Religious Freedom and the American Founding. You go into the state constitutions and how they set the stage for the First Amendment's like Bill of Rights and particularly free exercise protections. And I was just wondering, uh, what can we learn from state constitutional protections for religious freedom, both as they were at the time of the founding and as they are today?
Yeah, good. Thank you. I'm sorry, I forgot. You know, at the state level, so most church-state disputes were actually at the state level at the time of the founding. Um, there were some national issues, but really it was the states where all the action was. And in the state constitutions, in the state declarations of rights, and it's a little bit complicated, but the declarations of rights in some states were actually separate from the state constitutions. There in the state level at the time of the founding, you see the founders' philosophical and constitutional thinking. And to cut right to the chase, what they said about religious liberty is our right to worship is a natural right and an inalienable right, or unalienable is the term they used. So the state constitutions help us understand the philosophical thinking of the founders, and that philosophical thinking, which I try to unpack or uncover in my book, is what does it mean to possess an inalienable right of religious liberty? And the simple way to explain that is the founders believed in limited government. There's some things that the state can't do that we, the people, never authorize the state to do. And just a simple, really simple example that helps communicate this. Kathleen, if you want to be a lawyer, you're going to have to get a law license. And Mary Margaret, I'm sure, has a license. That's a license from the state. Or if you want to be a doctor, you have to get a medical license. If you want to be a kindergarten teacher, you get an educational license. So most professions are licensed by the state. I need a haircut. If you want to cut hair, you got to get a cosmetology license. But if you want to be a preacher, you don't have to get a preaching license. In fact, the state doesn't issue preaching licenses. Well, why not? Well, because we the people never gave to state authorities or to the national authority or to any governing authority the power to license who is or who is not a legitimate preacher. And that's just one concrete example of what we mean by limited government. There are some things the state doesn't have authority over, including who is or who is not a legitimate preacher. That's part of our unalienated right of religious liberty. Right. So we limit government in a way to protect church authority. And that's one of the lessons that the founders teach us that we need to keep on coming back to today.
Thank you, Professor. Um, Obviously, when you read the founders, not all of them agreed perfectly on every issue. So just as a procedural question, how do you make a judgment about what the general consensus of the founders would have been when you're looking back and reading their writings?
Yeah, that's good. That's a great question. So they agreed on some things, they disagreed on other things. So the way I put it, which kind of simplifies things, is that they agreed about the principle of religious liberty. That's part of what we were just talking about, that religious liberty is a natural right, an inalienable right. They all agreed on that. They disagreed on some of the practical applications. So I say they agreed in principle, they agreed on the principle of religious liberty. They disagreed on the practice of the separation of church and state. And the two main positions, again, to oversimplify somewhat, but get to the essential truth of it, is all the founders agreed that republican government, self-government, required a moral people. The simple answer there is because a free people is going to govern itself. You need to respect each other's property, right? If the people don't respect one another's properties and lives and possessions, you're going to need an increased police state. You can't have a free country if the people aren't basically self-governing, that people have to be moral. They all agreed about that. They all agreed that religion was useful to help cultivate morality. All the founders agreed about that. Where they disagreed was, does religion need the support of government? some founders like George Washington said, look, we need a moral people, and religion is indispensable to help people become moral. Therefore, the state should encourage and support religion. Others like James Madison said, look, we need a moral people, and religion is useful to help cultivate morality, but religion doesn't need governmental support. In fact, Madison said, religion will remain pure without the support of government. So that's a practical dispute. It's not a dispute on first principles. It's a dispute on secondary. It's really a dispute on policy. We think about the same things today. Should the government fund education? If you're starting a school, imagine you're founding a school today, a classical school, classical religious school. Should you take government money or not? Well, on the one hand, taking the government money will help you do what you want to do, and it can be very useful. On the other hand, well, if you take government money, there's going to be all sorts of strings attached. Right? Harvard University today is, under attack by the Trump administration, and they're vulnerable because they take so much federal funding. So if you're starting a classical school today, should you take government money or not? Well, you can have good arguments on both sides. Everyone could agree that education is good. All the founders agreed that religion was good and useful. But whether the state should support it or not, well, reasonable people can disagree. So I don't try to decide exactly who's right or wrong so much as to articulate the differences among the similarities on the one hand, the differences on the other, and then explain why they had those differences.
That's a great answer, Professor Muñoz, and it reminds me of a section of your book where you talk about the founders' understanding and their consensus around religious freedom as an inalienable right, which is kind of a contrast to how we think about it, or how the, I guess you might say, media or common kind of consensus portrays it today, where religious freedom is sort of a privilege granted by the government. Can you, first of all, for the benefit of our listeners, share some of the highlights from your book about how you explain what an inalienable right is? Because I think that's a term that we don't use too often outside quoting directly from the Constitution. And can you talk a little bit about how that contrasts with some of the misconceptions people have today of religious freedom as a privilege?
Yeah, well, I mean, these are big questions, and the two questions you asked take me about 6 weeks in class to explain. So let me see if I can do it very quickly. Again, the idea of an inalienable right or unalienable right gets at the limits on governmental authority. So really, the conception is jurisdictional. We don't give government authority over all things. Another classic example is that the mayor or the governor or the president doesn't get to choose. The president has no say on who the mayor of Washington, D.C. has no say over who the bishop or archbishop of Washington, D.C. is. This is what we mean by limiting governmental authority. So the founders primarily tried to protect religious liberty by having hard and fast limits on what the state could do. Most obviously, the state can't punish you for your worship or your failure to worship. So the religious freedom protects those who don't practice religion as well. You can't be fined or put in prison for failing to go to church. Doesn't mean that they thought going to church wasn't important. It's not the role of the government to enforce you going to church. Today, we tend to often think that religious freedom is protected by giving people exceptions from laws, especially laws that religious believers might find burdensome in their practice. And of course, there are a lot more laws. Government has grown in all sorts of ways. It interferes with our lives in all sorts of ways. For churches, employment laws, something Napa Legal is involved with, I think. Employment laws can limit churches on who they can hire. I mean, imagine if non-discrimination laws applied to the Catholic priesthood. Could the Catholic Church only have an all-male priesthood? And so the way we protect religious freedom today is through saying things, well, no, the Catholic Church in its selection of priesthood is not subject to or has an exemption from those general non-discrimination laws. Lots of people would say, well, that's a necessary adjustment given the modern regulatory state, given modern non-discrimination law. The founders' thinking was more, well, let's just prohibit or limit what government actually does, right? And if government does less, it will interfere with religion less. Well, now whether our adaptation of exemptions is just a reasonable way to approximate what the founders were trying to do under the modern regulatory state, or whether that's a departure from the founders' understanding, I mean, that's a question that's very much disputed among scholars. Can I give you one more? I feel that was too abstract for some of the readers. Let me give you a concrete example. The state of Oregon, about 100 years ago, passed a law saying that there could be no private schools, including private religious schools. You could only operate a public school, that is a government school, in the state of Oregon. So they outlawed Catholic schools in the state of Oregon, outlawed all private schools. Is the proper remedy for that solution to get an exemption for in this case, the Catholic Church, saying, oh, no, but Catholics can operate schools because that's part of their religious freedom? Or is the proper solution to rescind the law, say, no, the state of Oregon should not have passed such a law. That law inhibits not only the freedom of Catholic parents and the Catholic Church, but of all parents who might want to send their kids to a private school. And so those are two different approaches. Do you try to protect religious freedom from exemptions from burdensome laws, or by repealing burdensome laws? And the founders' approach was more the one of, it's not only repealing, preventing such burdensome laws from going into effect in the first place, not so much getting exemptions from them after the fact. That's a general statement. It's not to say that the founders didn't have some exemptions, but more generally, their constitutional approach was to try to prevent bad legislation rather than trying to get exceptions from bad legislation or burdensome legislation.
Thank you, Professor. You've been talking about the difference between how the founders thought about the right to religious free exercise and our sort of modern ideas. And so I was wondering, do you think that the founders' view was more protective of religious free exercise, or do you think the modern view with exemptions is more protective?
Well, I mean, that's not so easy to answer. I think many people agree that we want a society in which a pluralistic people can live together. Religious people of different faiths can live together, and religious and unreligious people can live together in the same society. People also generally agree that the rule of law means equality of all before the law. I think those are principles that almost everyone agrees with. It's very hard for especially traditional religious believers to live in especially blue states right now, because the modern regulatory state and non-discrimination law prohibits lots of behaviors, and it has employment regulations that limit churches in their own self-understanding and their own governance. So you could say the modern practice of trying to get exemptions from these laws, or general laws like the Religious Freedom Restoration Act that tries to legislate in a global sense exemptions, they're very protective of religious freedom. I think that's undeniable. On the other hand, having general exemptions and the availability of exemptions also facilitates the adoption of these burdensome laws. If you didn't have the exemptions available, you might not get the laws in the first place. Hard to know. That's a prudential calculation. Should a religious group that's burdened by a law try to get an exemption from it, or to try to repeal the law? That requires really good prudential judgment. And that's not easy always to know what to do.
That's a very thought-provoking answer, Professor. It just makes me want to go home and get back to rereading your book. And as we're dwelling a lot on kind of how the founders thought of this, what the consensus was, I'm going to hit on a hot button issue here. People often talk about a wall of separation between church and state, and that's a view that's often attributed to the founders. Can you put that phrase in context and talk about where did this phrase wall of separation come from, and what, if at all, is its kind of relevance to our analysis of the First Amendment today?
Well, the wall of separation in American constitutional law is usually dated to a letter Jefferson wrote when he was president. I think it was in 1801 or 1802. I can't quite remember. I think 1802 to the Danbury Baptist Association, and he uses the phrase wall of separation. If memory serves me right, Roger Williams used that same phrase in the 17th century, so it predates Jefferson. Of course, there's maybe on the one hand, most everyone would say, well, properly understood, a wall of separation, okay, but what do you mean by a wall? In modern constitutional jurisprudence, especially in the mid 20th century, the wall of separation was used to say religious groups, especially Catholic groups and Catholic schools, had to be excluded from otherwise available government funding programs. So the wall of separation, at least to his critics, was viewed as a wall of hostility towards religion. That phrase, I should say the phrase was adopted by the court in 1947 in a case called Everson versus Board of Education. It's known as strict separationism. You see it in the jurisprudence of Justice Sotomayor today. So Sotomayor would say religious groups can't participate, for example, in charter schools or school funding programs. Religious schools, religious groups have to be excluded because of the wall of separation. The majority of the Supreme Court has backed away from that approach. So the wall of separation as a constitutional rule has really gone out of favor. I think for good reason too. Even though Jefferson used the phrase, the modern Supreme Court understanding of the wall of separation that is not consistent with the founders' understanding.
So in light of that fact, where do you see the Supreme Court moving in the way that it thinks about these types of Establishment Clause issues?
Well, my specialty is predicting past Supreme Court decisions, not future ones. So I don't know. I can say what the Supreme Court has done, especially in Establishment Clause jurisprudence, it said our older understandings, our wall of separation decisions, we're going to abandon those. What takes its place is not altogether clear. Justice Gorsuch has written an interesting opinion in it's actually a free speech case from Massachusetts, trying to think through what a new Establishment Clause jurisprudence might look like. Scholars are trying to think through this. I mean, I have, if they want to read my book, if they listen to this podcast and take Mary Margaret's advice, they can see the approach I outline that they might take for the Establishment Clause. It's easier to say that our prior Establishment Clause jurisprudence was wrong. Originalists have been saying that for a long time. It's not as easy to say, and this is what an historical establishment actually was. This is what the founders meant by an establishment. That's a little harder to understand. Justice Scalia and Justice Thomas say a historical establishment was the coercion of religion. That might be true. It's a little bit odd, though, because the Free Exercise Clause already prohibits the coercion of religion. So that would make the Establishment Clause superfluous. And they haven't quite figured out how to deal with that. So, if there are young scholars out there listening to this, figuring out what the original meaning of the Establishment Clause is, the court is waiting to hear and write your law review article and win their opinions. And, we'll see what the court comes up with.
Thank you, Professor. I wish we could just go on all afternoon, but unfortunately, in the interest of time, I have to wrap up here. I know you have already written 2 books, God and the Founders and Religious Freedom or Religious Liberty and the American Founding, both of which I want to note are award-winning books and very well worth reading. Where else can our listeners go to follow your work and learn more about these issues?
Unlike every other professor, I don't have a website or anything like that. So I probably just a Google search. Most everything I write is available online, and maybe I'll mention, since I just received the page proofs today, I have a article coming out in the journal National Affairs. It's a general interest journal on, I think it's titled The American Revolutions of 1776, where I talk a little bit about our founding principles. I think the audience here will be interested in that essay, but a quick Google search, you can find my writings.
Wonderful. Well, Professor Muñoz, it's been an absolute privilege to have you on the podcast. Thank you for joining us today, and thank you again for introducing me to my husband. And thanks very much to our special guest, Kathleen Farnan, for her outstanding work at Napa Legal and all the amazing work on religious liberty and other legal issues we have no doubt that she'll be doing in the near future. So with that, I thank all of you as well, our listeners, for joining the Napa Legal podcast. If you enjoy our content, please don't forget to like, subscribe, and follow. We hope you'll join us again next week for another episode. Thanks and God bless.